Let's take a look at a key case within the law of tort. This is a case of Coventry and Lawrence which concerned the tort of nuisance. In this case, the claimant was Lawrence. They had moved to a bungalow in 2006 near to a motor stadium. This motor stadium ran speedway and stock car racing, as well as having a motocross track. They made a claim against Coventry and another who ran these motor-related businesses upon the basis of nuisance in the form of noise that had been created. The claimant sought to argue that there was unreasonable noise coming from the defendant's land as a result of the motorsport activities. The claimant had moved there in 2006. The stadium had received planning permission in 1975 and also had a certificate of lawful use for some of the activities. The claimant sought the claim upon the basis of the noise, and originally, at trial, they were successful in their claim for nuisance. However, the defendants then appealed upon various bases. They sought to claim the defence of prescription, that they had been operating for over 20 years. They sought to claim that the claimants came to the nuisance. They also sought to argue that there was no nuisance upon the basis of the character of the locality. And they also sought to establish that the planning permissions that they had been granted clearly established that their activities were lawful. The case progressed all the way to the Supreme Court, where the Supreme Court justices confirmed that the defendants were in fact liable for nuisance. They rejected the claim of prescription upon the basis that it had not been continuing as an actionable nuisance claim for the claimants for over 20 years. They further clarified that it is not a defence for defendants in nuisance claims to argue that the claimant has come to the nuisance. They also clarified that it was not a defence that planning permission had been obtained for the activities. The awarding of planning permission did not remove the right from claimants to seek actions for claims in nuisance. The purpose of planning permission is to balance the applicant's interest against public interest. This is very different to the wide range of interests that are considered in a case of nuisance. They did say, however, that the terms of the planning permission may be of relevance when considering nuisance, for example, looking at the time limits that they had placed on the activity. They also said in this case, which is relevant to the remedies which are ordered in cases of nuisance, that whilst it is usual that an injunction will be awarded for a finding of nuisance, the courts can be flexible and consider whether other remedies, such as damages, would be appropriate in cases. In this case, the defendants were found liable and the injunction awarded in the original case was restored by the Supreme Court.